So, hello once again. My name is Joanna Płatyńska, as you can probably read, and it's a pleasure to see you all, to meet you all via Zoom. But try to speak from your head, try to speak from your memory, or try to speak from your convictions, because when you read, you completely lost the judge. It's like like reading phone directory or reading a very boring novel. Uh, so it's better, to struggle and talk than to read perfectly, and also try to listen to judges when they ask you questions, because sometimes they ask questions just to help you to move to your next argument or to your next part of your presentation.
My name is Pei Tsai. I teach international law in Taiwan. And I participated in JESUP before, but it's way before last year. So I'm not going to say when. But ever since then, I've either coached or judged the Taiwanese rounds, the international rounds, and I'm the Taiwanese national administrators for the Taiwanese round as well. With my comments, and thank you again to both teams. I wish you the best for your remaining rounds, and hopefully, we'll see some of you in the international rounds. And thank you.
Good afternoon, everyone. Madam President, and Your Excellencies, may it please this honorable court. My name is Fakhrensa Khairzadeh, and as my co-agent indicated, I will speak for 22 minutes, representing applicants' remaining submissions. Madam President and Your Excellencies, moving to the third submission.
Early on, you mentioned that general principles can be found by looking into domestic legal systems. And now you're bringing us examples where international treaties also that may contain the principle nebis and item. So my question is, if we're establishing general principles by referencing domestic legal system, if that is the claim, then what's the relevance, or why are we considering international conventions in this regard? Because they are not domestic.
Principle of law and recognized by a civilized nation based on Article 38 of ICJ statute, but in civilized nations, it is recognized in their domestic legal systems.
Could you explain the difference between the two? Why these two arguments?
Defines general principle of international law as gap pillars which reflect the common core of domestic legal systems, and as fundamental norms derived from national legal systems and transposed into the international sphere.
Acquitted or convicted of a crime. Can you tell us what actually happened to her in Alex Strozier?
Your Excellencies, based on paragraph 46 of compromise statements of agreed facts, the charges against Ms. Scott were dismissed, and she was finally acquitted by Alex court.
And I'm seeing here that the reason why Ms. Scott was acquitted was because of some certain procedural issues. Now, I'm quite sure that the respondent is going to say that what we need for the nebis in idem principle is for there to be a finding of guilt as opposed to a procedural irregularity that ends the case. I mean, what do you have to say to this point?
On Article 14, Paragraph 7 of ICCPR, no one shall be liable to be tried or punished for same offense or crime for second time, for which he has already been convicted or acquitted, finally in accordance with the procedure of each country. The same wording in favor of nebis in idem principle is available in the some other instruments like ICC Rome Statute, as well European Convention for Protection of Human Rights, American Convention of Human Rights. ICC in Article 20 states that no person shall be tried by another court for a crime he or she already been convicted.
The reason why they let Ms. Scott go, right, is because, as you'll see at paragraph 43, what the Court of Appeal said, is because she wasn't advised of her rights when she was taken into custody. To put it in other words, the Court of Appeal, didn't, give, let her go because, she hadn't done the conduct in question. Do you think this is a problem?
Based on Article 26 of Vienna Convention on the Law of Treaty, every treaty in force is binding upon the party and must be performed by them in good faith. So based on mentioned international instruments, an item is be treated as general principle of law, and the respondent is bound to fulfill the provisions of ICCPR and extradition treaty, and the applicant did not violate the extradition treaty.
Legally speaking, what is the instrumentality of a state? I understand the relationship between NESCA and the applicant state in the present case, but I mean, factually, I understand that there's a connection. But legally speaking, what is the definition that you will give for the instrumentality of a state, and how does that match with NESCA in the present case?
Madam President, instrumentalities, enterprises, or a state-owned company which works under the control of a government and works under the control of a government, it is instrumentality of that state.
Of Pelman communities across borders, a judgment endorsing unilateral development without indigenous consent could be relied upon by the Soviet.
Sorry to interrupt. So, I mean, I understand that the two agreements have similar provisions, but let's say the court ultimately finds that Resova did not violate its obligation under Article 18 of the ARPA, for instance. What's stopping the court from finding a different conclusion if Solonia ever brings a case against Restovia on similar grounds?
A judgment endorsing unilateral development without indigenous consent could be relied upon by Restovia in the future relation with Solonia's undermining Solonia's ability to protect its indigenous population.
Can you identify exactly what the legal basis you're using now regarding the indigenous people's rights? I'm assuming it's not ARPA, so if it's not, can you just identify which basis it is?
Your Excellencies, customary international law, the free prior and informed consent principle is widely recognized as a customary norm protecting indigenous peoples' rights to participate in decision affecting their lands and resources, and also treaty laws like ILO Convention number 169 obliges states to consult indigenous peoples regarding development projects affecting their territories, and also United Nations Declaration on the Rights of Indigenous Peoples emphasizes the necessity of free, prior, and informed consent.
Could you tell me what the elements of customary law are? How is it formed in international law?
Yes, Your Excellencies, set practice and opinion juries. Set practice that there must be a consistent and general practices by states, and this means the state regularly acts in a certain way regarding a rule, such as consulting indigenous peoples before undertaking projects affecting, and also opinion juries. States must engage in the practice because they believe it is legally required, not just out of habit or convenience.
According paragraph 40 of the 46, the ECTHR and ABV, Norway and the United States Supreme Court in Hague.
Applicant referred to, for instance, the ICCPR to which the both parties to the present case are parties to or have not ratified. So, do we need to take the division item principle, I think in Article 14, paragraph 7 of the ICCPR into account when we consider whether this can be a bar to the application to extradite at all?
In paragraph 36, issue 4, State immunity of NICSCA, legal question distributed relative international law by dying state immunity to NICSCA and wrongful death suit. And issue 5. Mr. President, I now address issue 4. While short that distribute acted lawfully in dying state immunity to NICSCA.
Sorry, just to clarify, so you mentioned the fact that NICSCA has its own independent personality. So I'm wondering, or kind of the operation might be independent in some way. Why is that a relevant factor for the court to consider when deciding on issues of immunity?
Because grant immunity NICSCA has separate legal personality and operates independently. It's also not the organ or other ego of the state. Therefore, sovereign immunity does not attach.